Welcome, ladies and gentlemen. I'm Professor Michael Scharf, the Associate Dean for Global Legal Studies, and on behalf of the faculty and Dean of the Law School, I'm very happy to welcome you to today's event. Avi, if you'll come up for just a second. I just want to introduce to you as well Professor Avanan Cover, who is going to do the introduction of our speaker today. Avi is the director of our Institute for Global Security Law and Policy and has organized this and several other events. Okay. Thanks. All right, so he was a prop. I have other props. You know, this event, how many of you were here a month ago when we had General Mark Martins, who is the current prosecutor of the Al-Qaeda military commissions? Raise your hand. All right, so a lot of you were here for that, and this is sort of a bookend. And it's really special that this law school is able to have the former prosecutor who is going to tell you maybe some of the other side of the story that we didn't hear from Mark Martin, because what we do here at this law school is we pursue the truth, and we do it sometimes through being provocative. We have controversy, but it's always a pursuit of the facts to learn as much as we can about what's really the situation. And this is a perfect example of where you're really going to get both sides of a story, and then you'll be able to figure out what you in fact think is reality. Now, these two events are not the first time that this law school has dipped its toe into the issue of Guantanamo Bay. In fact, this has been a recurring issue for us for a while, and Colonel Mo Davis has actually been here 2 other times to speak to the law school during that time. During that period, we have had several major conferences that produce symposium issues of our Journal of International Law. And let me give a shout out, because I always forget to do this. Our Journal of International Law is going to publish this speech, and they help us organize these events, and often they are the runners for the microphones and so forth. But we had a symposium in 2006 called Torture and the War on Terror, and these little issues of the Journal of International Law weigh a ton. This one's about 550 pages. It's basically a book. And we have outside funding from the Wolf Family Foundation that allowed us to give this issue to all the experts in the field, so this was really making a big difference. We returned to the question in another symposium and experts meeting on security detention, which is the question of whether people can be held without charges for the entirety of a war if it's a war like against terror without end. And so we had this whole symposium issue on that. And then finally, quite optimistically, we had a symposium called After Guantanamo. Now, unfortunately, this was in 2009, and we thought that Guantanamo would be closed soon afterwards. And you'll hear from Colonel Davis that the struggle goes on to try to clear out Guantanamo, which has become a blot on the national reputation, international reputation of the United States. We also did something at the height of the controversy about the treatment of the detainees in Guantanamo Bay, which was to produce a document called The Cleveland Principles of International Law on the Detention and Treatment of Persons in Connection with the Global War on Terror. This document was signed by several thousand experts and academics, and it was given as a petition to Congress, and that led to hearings, which I was invited to testify at, about the reform of the military commissions. And one of the craziest stories, but truth is sometimes crazier than fiction, is that while I was testifying, they asked me a random technical question about hearsay evidence before military commissions, which I didn't know the answer to, but sitting directly behind me in the public gallery was Colonel Davis. And so I said to the chairman of the House hearing on this issue, I don't know the answer, but if you really want to know, why don't we just allow Colonel Davis to take my spot here for a moment and he'll give you an answer. And I thought that just made a lot of sense. Apparently that was the first time in the history of this chamber that happened. They did allow him to answer the question. He did a great job, and he was able also to make some other points that he wanted to. So we have been working on the issue of Guantanamo Bay. We also have been working on the other side, and this is very interesting about us. When Colonel Davis was the chief prosecutor, this law school entered into a memorandum of understanding so that our students taking what is known as the National Security Law Lab could prepare memorandum for the prosecutor's office. And we've been preparing those from the beginning, and we continue to prepare those. We've done over 30 issues. And so many of the issues that are being litigated have been outsourced to the students of this law school. Those of you who are students today that are in the audience, we still do this. And we also have a lab where we do work for international tribunals, for piracy courts, and for Interpol. So this is one of the areas where the law school is playing a real role in making history. So I just wanted to tell you a little bit about our role in this issue, and then I want to call Professor Cover up to introduce our speaker. One last technical thing. At the end of his remarks, he's going to take Q&A. I'm going to ask you to stand up and come to the microphones. We do not have runners today, so you're going to have to literally come and form a line at the microphones so that you can ask your questions. You can't ask them from the floor because this is being webcast throughout the world, and it's important that they hear your questions as well as the answers. So without further ado, my colleague, Professor Cover.
Welcome, everyone. I'm very pleased to introduce to you today Professor and ex-Colonel Morris Davis, who will deliver remarks entitled Eroding the Foundations of International Humanitarian Law, the United States Post 9/11. Professor Davis has been a front-row witness to this erosion. He has been an integral part of the United States' efforts to achieve justice for the harms suffered on 9/11, and he has also seen how these efforts can go awry. And he has not been afraid to sacrifice his job for his convictions concerning justice and fairness. Professor Davis has become an outspoken critic of the United States government's post-9/11 war against terrorism, and for that he has, like many other critics, suffered. But he remains unbowed. He continues to speak out. Indeed, he was even awarded this past year the Hugh Hefner, yes, that Hugh Hefner, First Amendment Award. And you too can be the beneficiary of his outspoken musings on his Twitter hashtag Colonel Morris Davis. I could recite to you right now just the litany of amazing positions that Colonel Davis has held, and I believe you may have his CV in the book. But I want to annotate, if you will, just very briefly, his CV. Having served in a host of positions in the Air Force, including as senior attorney and legal advisor to the commander at the 20th Air Force, and as assistant dean at the Air Force Law School, Mo Davis was picked in 2005 to serve as the chief prosecutor for the military commissions. And he proved himself to be a staunch supporter of the military commissions, vigorously seeking the prosecution of al-Qaeda members deemed unlawful enemy combatants. During his tenure as chief prosecutor, the Supreme Court held in Hamdan v. Rumsfeld in 2006 that the military commissions were unlawful because their structure and procedures violated the Uniform Code of Military Justice and the Geneva Conventions. And Colonel Davis then oversaw prosecutions under a new set of commissions authorized by Congress. But Colonel Davis's conscience was affected. He became concerned with many of the flaws in the commissions. And in late 2007, in a surprise to many, Colonel Davis resigned over Pentagon interference with his independent role as prosecutor. The Pentagon had sought, in particular, the prosecutions of high-level detainees over the recommendations and wisdom of Colonel Davis, and had sought the use of classified evidence despite in closed sessions of court, despite Colonel Davis's insistence that those trials be held open and transparently and fairly. And in a remarkable turn of events, Colonel Davis was actually called to testify by Hamdan. Salim Ahmed Hamdan, who had brought the case all the way to the Supreme Court, was called to testify by Hamdan's lawyers about the military commission's contaminated process. After his resignation, Colonel Davis served as assistant director and senior specialist for the Congressional Research Service at the Library of Congress. In late 2009, he criticized the Obama administration's plan to use both military commissions and federal courts. 9 days after his criticism, he was fired by the Library of Congress. Professor Davis is now represented by the ACLU in a lawsuit against the Library of Congress seeking to vindicate his First Amendment rights to express his personal opinion. Professor Davis now teaches at the Howard University School of Law, and we are delighted to have him here back again at Case Western, where we will sit in these rows to hear of his observations and experiences. So thank you, Professor Davis.
Well, thank you. It's a real privilege to be back here at Case Western. As Professor Scharf mentioned, this is my third time standing here and talking to this audience. Some of you have been here for all three, and for some this is the first, but it really is a privilege. I mean, for two counts mainly. One, it's good to be out of Washington. The air just seems much fresher here in Cleveland than if you were up last night as I was, watching to see if our government was going to pass a budget and get back to work. And it just seems a lot fresher here than it does back in D.C., so I'm glad to be here and not there. Second, and probably most importantly, I told my wife before I left, I said, God, I hope they give me another one of those Case Western pullover fleece jackets, because I got a blue one when I was here the first time, and I got a tan or a beige one the second time, and this time I got a gray one. And I've just about worn out the first two. So I've got to come here at least every 2 years to get a new pullover, because I wear those things constantly in the summer. Apparently there are a lot of Case alumni in the DC area, because when I wear it I get stopped quite often going, hey, did you go to Case too? But I think after, this is my fourth trip, because Henry King invited me back for the Niagara Moot Court competition. So I think after 4 trips here I at least qualify for a master's or something. So it really is a privilege, and thank you to Professor Scharf and Professor Cover and to Ms. Pratt and all the others that have gone out of their way to make this possible. And also thank you to Howard University for allowing me to be here. As Professor Cover mentioned, I resigned during the Bush administration, which didn't endear me to the Republican side, and then I criticized President Obama for backpedaling on Guantanamo, which didn't endear me to the Democrats. And in Washington, when you aggravate both the Republicans and the Democrats, finding a job can be difficult. So I'm very grateful to Howard University for giving me a home for the last 3 years, and the freedom to go out and write and speak and do the kind of things that I think are important. So it's a great privilege to be here. At times I feel like Don Quixote, tilting at this windmill at Guantanamo that's been there now for 11 and a half years. And this military commissions process that President Bush authorized on November 13th, 2001, so almost a dozen years that we've been attempting this process, and it's been a failure. And it's discouraging at times, but to me, I'm optimistic because of people like you, that you'll take an hour out of your day to come and sit and listen, and you came before to hear General Martin, and I really appreciate that you're willing to take time to think and listen, where the vast majority of the public, this is out of sight and out of mind, and they don't really care. So I commend you for your commitment. So what I want to talk about today is how I went from the guy on the top row, when I'm standing on the steps of the courthouse in Washington or standing on the steps of the courthouse at Guantanamo, defending the process, the leading advocate for Guantanamo, to the person on the bottom row who is speaking out in the media, who went from standing on the steps of the courthouse to standing on the steps of the White House leading a protest to close Guantanamo. It seems like a change of position that seems impossible to imagine, and I'm often asked if the top row, if I was insincere and just towing the company line. And what I hope to show you today is I wasn't. I believe that we were committed to doing this right. I mean, I told the first meeting I had with the prosecution team in 2005, this school has a close connection to Nuremberg and Henry King. When I was here in 2006 and I spoke, there was a faculty luncheon. I did a presentation for the faculty at the luncheon, and Henry King came up to me afterwards and stuck his finger out and said, "It was important to Robert Jackson that we do it right at Nuremberg. Don't you screw it up at Guantanamo." And I told the prosecution team in that first meeting that we're going to do this right. We're not going to use evidence obtained by the enhanced interrogation techniques that went too far. And I don't want any of you to do anything that you feel is illegal or immoral or unethical. I would like for our grandkids to be able to look back at Guantanamo the way that we look at Nuremberg. And so I believe that we were committed to doing that for a number of years, but by the summer of 2007, I became concerned that that wasn't our commitment, and that was when I chose to resign. So I've got kind of an aggressive agenda for today. There are really 4 segments to this talk, and each of those segments I've done hour-long talks on each of the segments, so trying to take 4 hours and cram it into about 30 minutes is going to be a challenge, so hang on and we'll try to get through this, because I think it's important. I mean, President Obama has given a series of talks. Unfortunately, we don't need a lecturer, we need a leader. And I think that's where this administration has failed in providing leadership on this issue of the war on terror and how we choose to respond to it. Because as the President said in the speech he gave in the National Archives back in May of 2009, it really is our values and our principles. And when you talk about American exceptionalism, that's what made us exceptional, our belief in the rule of law. Unfortunately, since 9/11, the rule of law is a law, laws that are consistently, well-known and consistently applied. But unfortunately, we've treated the rule of law as a slide rule, where it slides to fit whatever we find convenient at the moment. And I think it's in our interest to get back to being the champion of the rule of law and not just people that talk about it. And there have been a number of critics of the administration and the U.S. in this post-9/11 policy that we've adopted, where there are rules that apply to others. We condemn others for doing things that we condone when we do it ourselves. And I think you have to question, we have this incredible technology, we have the strongest fighting force in the world, this country with incredible capability. But are we accomplishing what we really want to accomplish when we're using this power in ways that I think may be tactically advantageous at the moment, but I think long-term strategically, we're going to regret some of the decisions that we've made. So real quickly, if you think about, I have people ask me that, it seems like an oxymoron, the law of war. If you're angry enough to go to war, then it ought to be, in some people's mind, any means necessary to win. And this notion of having rules that apply just doesn't seem to fit for many. But if you think about conflict, if you go back to the early days, back in the early days, the original first days of man, if you wanted to kill someone, you had to actually have physical contact with them. You had to pick up a rock and hit them in the head or strangle them or do something where you had to actually physically contact them. And then the sword came along so you could stand 3 feet off and kill them, and then the bow and arrow, you could be 20 or 30 yards away, and then the musket and all the things that have evolved to this. We've made it so much more convenient to kill each other. For example, currently there's a debate about the drone policy, which I think is a bit of a misnomer. I'll talk about drones more a little later, but you've got the drone operators. At Creech Air Force Base in Nevada, it's a picture of the base housing at Creech Air Force Base. So, they get up in the morning, they have breakfast with the kids, go off to the office, sit in a comfortable chair in an air-conditioned room, and then 7,650 miles away on the border of Afghanistan and Pakistan is where the drone strikes take place. And then at the end of the day, they go home, they attend their kid's soccer game, and go to bed and get up the next morning and do it all over again without ever actually having to see or have contact with the people that are being impacted on the other end. So we've made it so convenient to kill one another that I think it's critically important that we have rules in place for how we use that power. Now, the evolution of international humanitarian law or the law of war is not something that just occurred. You can go as far back as Moses. Go back to Deuteronomy. And in there it talks about the rules that apply when you are holding a city in siege. And then up to Hugo Grotius and the just war theory, or Henry Dunant in his book, Memories of Solferino, and the battle that took place there that led to him leading the effort to create the International Committee of the Red Cross that to this day is still the leading organization in IHL. And Henry Dunant was the winner of the first Nobel Peace Prize, which President Obama went on to win later, and who I think is the only Nobel Peace Prize winner with a kill list. And then on to Francis Lieber, who during the Civil War drafted at Lincoln's request the Lieber Code that Lincoln implemented that were rules governing the conduct of Union forces during the Civil War. So we've had this long history of having rules on how we conduct conflict. So I want to jump forward from that to kind of the modern era, which I think really began with World War II. You know, one of the nice things about being, the United States is we won. I mean, if you notice the people that are held accountable in war crimes tribunals, you don't see the winners showing up in those tribunals. 'Cause I think people could argue reasonably the use of nuclear weapons. We're the only country that has ever used nuclear weapons. And I think you could make an argument on whether that, proportionality and necessity and all those things, you could make an argument. But fortunately, we won and we didn't have to answer those questions. But we saw what happened during World War II. The atrocities that took place, and at the end of the war, we were pretty much left unscathed. Europe was decimated, Russia was decimated, Japan was decimated, and we were largely left as the real superpower in the world. And so after witnessing what we had seen in World War II, the United States became the leader of the effort to codify this body of international humanitarian law in order not to repeat the mistakes that we saw during World War II. One of the things we did, as Henry King is certainly famous for, were the Nuremberg trials, where rather than, as some wanted to do, just taking the Nazis out and shooting them, we actually gave them trials. And some of the accused were acquitted, and some were ultimately executed, but we didn't just take them out and shoot them. We put together a process that by today's standards doesn't measure up. But by the standards that existed back in the 1940s, Nuremberg was an incredible accomplishment and one that we ought to be proud of. And from that, in 1945, we brought the nations of the world together and we created the United Nations. The last big conference was held in San Francisco in 1945, and later that year, most countries signed on to the UN Charter, which again is a body of law to try to regulate the use of force. And essentially, well, hopefully if we have time at the end, we'll talk just a minute about one of my concerns was when we were about to bomb Syria and whether that was permissible under this body of law that we created in the UN Charter, where it says, you have the right to use force if you've been attacked or if imminent self-defense or with the authorization of the international community, none of which, in my view, applied in Syria. But we led the effort to create this organization to try to resolve conflict and avoid having wars and to regulate the behavior of countries. We also led the effort in the creation of the Geneva Conventions. Again, a body of law, the various conventions that govern the treatment of detainees and the protected status of personnel, of civilians and medical personnel and others, to try to contain the effect of armed conflict, to keep it to the battlefield and amongst the combatants, and to protect and mitigate the suffering of others, and we led the effort. So coming out of the World War II era, we were the champion of international humanitarian law, this body of law that we wanted to spread around the world. The Senate held hearings in 1955 on ratifying the Geneva Conventions, and Deputy Undersecretary of State Robert Murphy testified at those hearings. And you can see what he said here about the Geneva Conventions and why the Senate should ratify them, saying that they reflect the enlightened practices as carried out by the United States and other civilized countries, and they represent largely what the United States would do whether or not a party to the conventions. Our own conduct has served to establish higher standards, and we can only benefit by having them incorporated in a stronger body of conventional wartime law. So you hear that talk about the United States being that shining city on a hill and a light into the world. Undersecretary Murphy was saying, look, in the conduct of war, we are the benchmark. We set the standard, and by adopting this body of law, we're bringing everybody up to our example and our standard. Now fast forward a bit to, and many of you in this room are too young to remember, but the first Gulf War in 1991. If you recall, when the ground war started, our troops went from the border of Kuwait and Iraq to the outskirts of Baghdad in about 100 hours. We had a total of about 120 casualties during the war. Some of those were accidents and heart attacks and other things. There were few that were actually combat fatalities. And if you recall, the bottom picture shows the Iraqi forces surrendered by the tens of thousands without firing a shot. Why did they do that? Anybody? Why did they surrender rather than fight? When they saw the U.S. forces, why did they put their guns down and put their hands up?
They knew they were safe.
Exactly. They knew who we were. We were the good guys. That rather than fight, if they surrendered, the United States would give them shelter and food and medical care. They wouldn't be abused, and they chose to quit. I can tell you, as a guy who spent 25 years in uniform, I would prefer the enemy put down their guns and put up their hands and say, I quit. I mean, I think it's in our national interest to regain that reputation, because I question today. I mean, if you look at the attitude in that region about the U.S. after things like Abu Ghraib and Guantanamo and waterboarding and indefinite detention and drone strikes, those guys you see at the bottom, if they thought they were going to be held indefinitely, sexually humiliated, waterboarded, would they put their guns down and quit? Or would they fight? I think many would fight. So I think it behooves us to get back to the day when the U.S. was viewed as the good guys, that you could trust to treat you right and not to abuse you the way that we've done since 9/11. Because, we used to be the land of the free and the home of the brave, and after 9/11 we became the constrained and the cowardly. Where what we stood for, those principles that President Obama talked about, became an inconvenience, and we were scared, and we told the government, do whatever you got to do to keep us safe. I mean, I tell my students at Howard, I'm old enough to remember going to the airport, and if somebody felt you up, it was called a sexual assault, not pre-boarding. That's become the new normal. If you look at the American Red Cross did a survey on torture, and a majority of the public is shifted. During the Bush administration, a majority of the American public was opposed to torture. Now a majority of the American public is okay with torture, and the younger the person asks, the more accepting they are, because there's this whole post-9/11 new normal that many have grown up in and come to accept. So I hope we can get back to a day when we don't focus on 9/11, we focus on 9/10 and how we lived before we got scared. And I think we ought to go back to being the land of the free and the home of the brave and quit living in fear. But remember, this body of law that we led the effort to create? After 9/11, it became an impediment. And you can see the memo from Alberto Gonzales to the president saying that the Geneva Conventions, remember the thing we led the effort to create? That many of the limitations on questioning enemy prisoners are rendered quaint, and that in my view that some of the provisions are obsolete. So this body of law that we led the effort to create, we now are discarding and setting aside as being quaint and obsolete, because it's an impediment to what we want to do, which is to avoid the law. You had the memorandum from John Yoo, where again he says that the Geneva Conventions and international humanitarian law don't apply to this conflict with Al-Qaeda and the Taliban. Now, there were some that pushed back. William Taft was a legal advisor to Colin Powell at the State Department. You can see this is his, John Yoo's memo was on January 9th, 2002. Taft wrote back to him on January the 11th, 2002. Does anybody else know what happened on January the 11th, 2002?
Guantanamo.
The first detainees, the plane landed at Guantanamo that same day, January the 11th. Why did we choose Guantanamo to detain these guys? Why fly them halfway around the world? Why not detain them there? Why did we take them to Guantanamo?
I mean, the legal argument was it's a U.S. military zone, but it's outside the contiguous United States.
So no law applied. Remember, what made us exceptional was our belief in the rule of law, and now we're doing everything possible to avoid the law. Saying the law doesn't apply, and picking this site that we thought was a law-free zone that the U.S. courts couldn't touch and the international courts couldn't touch and the Cuban courts couldn't touch. It was the perfect place to exploit people for intelligence. So we chose Guantanamo. And you see, we had people push back like William Taft did, saying, look, I agree that, we really want to see, what the boundaries are of what we can do in this war on terror. But you can see in this bottom paragraph saying, look, some of your conclusions you admit are questionable, and as this document will show, I expect that you'll find they're actually incorrect as well as incomplete. And he ends it saying, we should talk. And of course they didn't, because anybody that pushed back against what the administration wanted to do, which included all of the judge advocates generals of the military services, people in uniform, were uniformly opposed to Guantanamo and to the use of torture and to the use of military commissions. But like William Taft, they were marginalized because they weren't saying what the administration wanted to hear. And so we moved forward. There's a memorandum by Jay Bybee, who at the time was the Assistant Attorney General. Anybody know what Mr. Bybee does now? This is called the torture memo that he authored. Anybody know what he does now? He has a lifetime appointment to the United States Court of Appeals for the Ninth Circuit. It was his, punishment for having written the torture memo. In the memo it says, now again, remember, we're the champion of the rule of law, the example, the shining city on a hill. And in this memo it says, Section 2340, that's out of our domestic torture statute, that anything we do in questioning detainees that doesn't produce the level of pain that would be caused by physical injury such as organ failure, impairment of bodily function, or death, anything short of that's fine. Stop and think about that for a minute. The United States is saying any pain that's less than being strangled to death or your heart stopping, anything short of that, we're good to go. Which to me is a pretty remarkable statement for the United States to be making if we're the example for the world to follow. Probably even, to me, more incredible, later in the memo it says, okay, even if you could make an argument that level of pain is a violation of the torture statute, then it would be unconstitutional. Because, as it says, the president enjoys complete discretion in the exercise of his commander-in-chief authority and in conducting operations against hostile forces. So what does that mean? It means that neither Congress nor the courts have any authority to tell the president, you can't do that. So whatever the president says is untouchable, whether it's torture or kill list or indefinite detention, that the president has the unilateral authority to act, and there's nothing that anyone can do to challenge it. All right, so in this body of international humanitarian law, now again, I think many of you are too young to remember this, but there was a time when Congress did things on a bipartisan basis. So back in 1994, we led the effort to create the Convention Against Torture. And after the convention was passed, it came to Congress to be ratified in the Senate. And I forgot what the vote was. It was like 95-3. It was, hugely popular on a bipartisan basis, and a lot of great speeches given on the floor on why it was in our interest to sign on to the Convention Against Torture. And it's interesting if you look, because the discussion centered on the fear of Americans being the victims of torture, not the perpetrators of torture. But in the Torture Convention that we led the effort to enact, it says there's no exceptional circumstance whatsoever for torture. It says that every party to the convention has to provide a legal mechanism for alleged victims of torture to seek compensation for their mistreatment. And it says you can't outsource torture. You can't hand someone off to another country that has a more morally casual attitude and let them do your dirty work. it's prohibited by the convention. Now keep those provisions in mind. No exceptional circumstance whatsoever, a system, legal system to provide compensation for alleged victims, and no outsourcing torture. All right, did we torture or did we not? I mean, I think it's clear that we did. I mean, John McCain has talked about it. Many others have talked about it. When I resigned as chief prosecutor for the military commissions, the person in charge of the commissions was Susan Crawford, who you see pictured here. She had been Dick Cheney's inspector general when Dick Cheney was the Secretary of Defense. And I mean, you just don't get more Republican or more endeared to the Bush administration than Susan Crawford. And Susan Crawford dismissed charges against Mohammed al-Qahtani. It was the one case that I was personally handling myself. He was the 20th hijacker. The guy that, when he landed in Orlando, and an alert customs agent thought his story just didn't make sense and put him back on the plane and sent him home, and he never made it to rendezvous with the other 19. But we mistreated al-Qahtani. It was the dirtiest of the cases before the high-value detainees arrived, and I was handling it personally. And in the spring of 2008, Ms. Crawford dismissed the charges against Mohammed al-Qahtani. In January of 2009, you can see on January 14th in this article by Bob Woodward in the Washington Post, Ms. Crawford said she made the decision to dismiss charges because, quote, "We tortured al-Qahtani. Our treatment of him met the definition of torture, and I dismissed the charges." Mark Fallon was the deputy commander of CITF, the Criminal Investigation Task Force, a military organization that was responsible for trying to collect up all the bits and pieces of information on the detainees for us to be able to sit down with them and determine if there was a case that could be prosecuted. He was at Guantanamo in October of 2002 in this meeting with all the other agencies that were involved, and this is an email he sent back to his boss saying, "What I'm seeing down here are the kind of things that congressional hearings are made of. That someone from another organization, the CIA, said that if the detainee dies, then you're doing it wrong." And he goes on to say that, in his view, that someone ought to be paying attention to this because history is not going to look back favorably with what we were doing at Guantanamo. So what happened to all the people that put us on this road to turn our back on the law and to engage in torture and to do all the things that we've done? They've all been handsomely rewarded for their conduct. Jose Rodriguez was the head of clandestine operations for the CIA. You may recall there were videotapes of Abu Zubaydah and al-Nashiri being waterboarded. A judge had ordered that they be preserved, and Mr. Rodriguez ordered that they be destroyed because they thought that the risk of that information getting out in the public, and the public seeing what our government was doing, was more harmful than ignoring the order and destroying the evidence. As you can see, the Obama administration made the decision that Mr. Rodriguez should not be prosecuted for what he did. Instead, he wrote a book, and he's on the lecture circuit and making a lot of money off of having sanctioned torture. In fact, if you look, the only person that's gone to jail for torture is not someone that sanctioned it or not someone that conducted it. It's John Kiriakou, who was a CIA agent who talked about it. And John's doing 30 months in federal prison for having disclosed the name of a CIA agent who was involved in torture. So we don't punish the torturer or the people that put the policy in place. We punish the guy that had the audacity to tell the public that we engaged in torture. Now again, I mentioned the torture statute. As part of the torture convention, every country had to sign on and have a domestic law that criminalized torture. We had one. Again, it passed with flying colors in both the House and the Senate. We've used it one time. We prosecuted Chucky Taylor. Charles Taylor, the former president of Liberia that was convicted at The Hague not too long ago. We prosecuted his son in federal court, so we know how to use the statute. We prosecuted him for the atrocities he committed in Liberia, and he was sentenced to 97 years in prison in federal court. So we know how to use the statute, but we've never used it. Maher Arar was a Canadian who flew to Tunisia with his family, and on the way back at JFK, he was taken off the plane, held for 2 weeks in the U.S., and then we put him on a plane, flew him to Jordan, and from Jordan he was driven to Syria. Now remember, Syria, Bashar al-Assad that we were planning on bombing not too long ago, we turned over Maher Arar to that same government where he was tortured for about a year until they realized he was a nobody. The Canadians who had given us the information that led us to believe he might be a somebody have apologized and paid him $10.5 million for their part in us sending him off to be tortured. When he sued here, remember this convention says there has to be a means for people that are alleged victims of torture to seek compensation. The Obama administration asserted the state secrets privilege, and the case was dismissed. And we've never even apologized to Maher Arar for the year he spent in prison in Syria being abused thanks to us. He's an incredible guy. He spoke to I teach a class in national security law, and he spoke to my class by Skype because he's barred from coming to the U.S., but he's a remarkable guy. He's completed his PhD, and just a really interesting person that if we can't apologize to Maher Arar for sending him to Syria, what does it say about us? And so again, not a single person that's alleged that they've been tortured has been able to hold the government accountable, either criminally or civilly, for having been victims of torture. So if people tried, if we can't sue the government, let's sue the contractors, the businesses that profited by helping the government send us off to be tortured. So they filed suit against Jepson, this company that does aeronautical planning. And what did the administration do? They asserted the state secrets privilege, saying for this company to defend itself, we'd have to give them classified information, and therefore the case should be dismissed, and it was. So now you can't sue the government, and you can't sue the companies that profited by helping the government when they outsourced torture. In fact, the latest company that was sued was CACI. The case was dismissed on jurisdictional grounds, and the victims, alleged victims of torture, were then sued by CACI for the alleged facilitator of torture to recover their attorney fees. And the court said, well, we do have jurisdiction to hear that when they've ordered the alleged victims now to pay the company that they had sued. I don't know, any see Zero Dark 30? I didn't. I wasn't going to, if it comes out in the red box, I might spend 99 cents to see it, but I wasn't going to help support. You guys, again, are probably too young to remember. I remember when Jaws came out. I had never seen a shark, but after seeing Jaws, I had some pretty firm opinions that the only good one was a dead one. My fear was Zero Dark 30 was going to do for torture what Jaws did for sharks, and people that had no experience with torture were going to sit down and watch a movie and come away with the conclusion that 30 minutes of torture leads to Osama bin Laden, therefore it's a good thing. And that was not the case. Actually it's 5 years ago now, I did an op-ed in the New York Times criticizing our relaxing of the standards and using torture. If you really want to know about torture, there are two books I'd recommend. One by Matthew Alexander, which is a pseudonym. He's actually a former Air Force officer named Tony Camarino, who had to write using a pseudonym at the time. And Ali Soufan was an FBI interrogator who actually was the first to interrogate Abu Zubaydah and others. So these are guys, they're not like Dick Cheney, who has never interrogated a person in his life. They're people that spent their careers doing interrogations, and they both tell you torture doesn't work. I mean, it's great for making somebody talk, but it's not good for making them tell you the truth. And the purpose of an interrogation is to get useful information, and they say it doesn't work. Now, some other countries have not been as casual in their attitude about this as we have. The Italians have convicted 23 Americans for the abduction of Abu Omar, and then he was sent off to Egypt where he was tortured. So, there are people that aren't quite as cavalier about it as we are. Now, at Guantanamo, again, we picked Guantanamo because it was viewed to be outside the reach of the law. There's an article recently, Miami Herald is suing under FOIA, trying to get in. Camp 7 is where the high-value detainees are held. And as you can see, over the time that Guantanamo has been open, about 11 and a half years, by the end of this fiscal year, by September 30th of next year, we will have spent $5.25 billion to detain people at Guantanamo, or $2.7 million a year per person. Now, there are 162 men at Guantanamo. There are 779 that were ever held there. There are 162 that are left. 82 of the 162 are men that the CIA, the FBI, the Department of Justice, and Department of Defense unanimously agree didn't commit a crime. We're not going to charge them. They're not an imminent threat, and we don't need to keep them. Now, that conclusion, they published their report in January of 2010, saying these are men we don't need to keep. They're still there at a cost of $2.7 million a year each. So, you know, for the fiscal conservatives in the crowd, economically, Guantanamo doesn't make sense, in addition to the cost we paid as far as our reputation. The military commissions, like I said, next month will be 12 years since they were authorized. There have been a grand total of 7 trials completed. 5 of those 7 men aren't at Guantanamo anymore. They've gone home. So one of the jokes we used to make at Guantanamo was you got to lose to win. Because if you got charged with a war crime and convicted as a war criminal, you got a 5 in 7 chance you're not at Guantanamo anymore. You're back home. But if you're never charged with a war crime, you could spend the rest of your life sitting there. So I'm pleased that the administration, in the picture, you got Abu Hamza al-Masri, who was extradited from the UK to the US. You got Abu Anas al-Libi in the upper right-hand corner, the recent capture in the raid in Libya. You've got bin Laden's son-in-law, whose name is escaping me. I can think of his name now. And you've got Ahmed Galani, depicted in the bottom corner. What's unique about those 4? What do they have in common? They're either have been or are being prosecuted in federal court, not in a military commission at Guantanamo. So I think it's a pretty powerful statement. Like with Abu Hamza al-Masri, we had to promise the UK, you know, our closest friend and ally, we had to promise we wouldn't take him to Guantanamo, we wouldn't prosecute him in a military commission, which is a pretty strong statement from our closest friend on what they think about Guantanamo and the military commissions. And the president has chosen, you know, Ahmed Galani, when I was the chief prosecutor in September of 2006, a plane landed at Guantanamo and 14 men got off. Only 1 has been convicted and sentenced, and it was Ahmed Galani in federal court, not at a military commission in Guantanamo. So I started the petition in May of this year to close Guantanamo, and just mainly because of my own procrastination, it happened to go up the morning that the president talked about Guantanamo at a press conference. So it looked like it was this coordinated process, but it was entirely a fluke that it happened on the same day. But 23,000 people signed my petition to tell the president to close Guantanamo. And he invited me to his speech he gave in May, where he said, we're going to close Guantanamo. It's a blight on the country. And here we are in October, and there's still 162 men, the majority of whom have been cleared for transfer, that are still at Guantanamo. And then let me end up with drones. Here's a list of, I mean, nobody has an exact figure on how many people have been killed in drone strikes around the world, but I think this is probably as good a data as you're going to get. So I know the administration likes to portray it as this precision weapon where we can, you know, mitigate the risk to the civilian population, but it's not error-free. And there's no doubt that a lot of people have died as a result of drone strikes. I'm not opposed to drones as a weapon system. It's like an F-16, but instead of sitting in the cockpit, you sit in a air-conditioned room at Creech Air Force Base and fly it. It's our policy for how we use it that causes me concern. Mainly this policy of having a separate agency. You know, the military drone program comes under IHL and the law of war. But we have another drone program run by the CIA, a civilian agency that's not part of the military and not covered by IHL, carrying out lethal offensive military operations. And I don't know any legal basis for the president to tell a civilian agency to go kill someone in another country. So I'm concerned about the policy that we've used. You know, a majority of Americans are opposed to drone strikes on Americans, like we did with Anwar al-Awlaki and his son. But you see, we're opposed to using them on us, but we're okay with using them on other people. But other people aren't happy about being on the receiving end. You know, we want to win hearts and minds in this war on terror. In Pakistan, 3/4 of the Pakistani public, you know, where we have spent billions of dollars, 3/4 of the Pakistani people consider us to be the enemy. You've had the UN sent Ben Emerson, to Pakistan. He concluded that our use of drones there has been an invasion of their sovereignty that we certainly wouldn't condone if someone was doing the same here. And more recently, you had Malala, who last week told the president, hey, stop droning us because you're making enemies and innocent victims in Pakistan, yet the program continues. So I want to just wrap up real quickly. This is my concern on where we're headed. So bear with, this is just a short 3-minute clip. I think this is what you ought to be thinking about going forward in the precedent that we're setting in this effort.
The use of drones is just one way the U.S. military has approached unmanned combat, but the Pentagon is also exploring another way. For more, CCTV's Jim Spellman joins us from the newsroom with more. Jim.
Elaine, they look like something from a science fiction movie, but they are very real, and some fear these robots could become the drones of the future.
He looks like a soldier, moves like a soldier, and marches like a soldier. But underneath that camouflage uniform, Petman is something very different. Petman is a robot designed to test uniforms built by an American company called Boston Dynamics with funds from the U.S. Department of Defense. In the near future, robots like Petman and other less human-looking machines could be used to keep first responders out of harm's way during disasters like wildfires or the Fukushima nuclear disaster. But experts say it is inevitable that machines like these will one day be used in battle.
It'll be a substitute for what in the past would have been a human being in a cockpit or a human being in a tank or a foot soldier.
For now, most of these robots are controlled by operators, but research is focusing on creating fully autonomous robots who will make their own decisions when performing their missions. Enter Atlas. Standing nearly 2 meters high and weighing 150 kilograms, Atlas is being provided to 8 universities and research labs for further development, including greater levels of autonomy. There's no indication that any of these robots are meant for the battlefield, but fears that fully autonomous robots could be the next major evolution in weaponry concerns groups like the Campaign to Stop Killer Robots and the United Nations, which released a report last year calling for a moratorium on lethal autonomous robots until a legal framework for their use can be established.
We're headed in that direction to where machines are going to be autonomous and can make their own decisions, but who is going to be accountable?
Like the drones currently in use, robots have the potential to greatly reduce the loss of life for the country that has robot superiority, something that may make conflicts easy to start and hard to finish.
Americans aren't coming home in body bags because of drones, and it makes it palatable to the public.
Someone's coming home in a body bag.
But not us.
Ultimately, what is at risk may be our humanity, as the line between weapon and warrior continues to blur.
So how far off is it until we may see fully autonomous robots? The U.S. Department of Defense won't say how far along they are, but defense systems with varying degrees of autonomy are already in place in Israel and the demilitarized zone between the Koreas and on some U.S. naval vessels. And right now, the UK is testing a semi-autonomous stealth drone called Tyrannus, which can find and choose its own targets. At the moment, it is said to need an operator to make the final decision to engage a target. So still a few steps away from full autonomy, Elaine.
All right, CCTV's Jim Spellman in our Washington newsroom. Thanks.
Oops, this requires glasses. All right, so let me just end up with, it's not so far off. There's a really good book I'd recommend called Wired for War by Peter Singer, where he talks about, drone technology, he says, is like comparing the Model T to the Tesla. He said, we're at the Model T stage with drones, and these autonomous machines to carry out warfare is like the Tesla, and that's where we're headed, as this shows. I just saw this morning, I was looking for, I came over here and added this to the slides. 37 countries are now calling for a ban on autonomous lethal weapons. Because if a machine can make the decision, who's accountable? Because at the center of international humanitarian law is accountability. That someone has to be accountable for the decision. So I'd commend to you Wired for War. And again, back to President Obama, when the bodies of Ambassador Stevens and the others came back to Andrews Air Force Base, the president gave a talk there on the tarmac, and he talked about their sacrifice and the sacrifice of men and women serving the country. And he said, the country that we love will always shine as a light unto the world. I think we do, but I think for the last 12 years, we haven't been a guiding light, we've been a warning light. And that we need to return to our principles and our values and that body of law that we championed and stand up for international humanitarian law and those principles. Because again, as I said, it became important, I think, with Syria, where we were about to launch an attack on Syria when we hadn't been threatened or attacked, and I think you can certainly debate that, but I'll end there. I'm a couple of minutes over what I'd intended, but there's a few minutes left.
Let's do 10 minutes of questions. We'll end
Sure.
at 5 after, and then there's a lunch reception in the rotunda behind this room.
I guess I'll start.
Okay.
I'm Richard Wannerman. I'm a student, second year student here. Getting back a little bit to the detentions and prosecutions, I believe there was some initial rumblings back in 2009 of closing Guantanamo and possibly moving all of them to federal courts, or at least moving them onto U.S. contiguous territory. But the political pressure has obviously been very high. Then there was the move to move into Michigan, to the abandoned prison. And then that was scuttled because at least a sizable enough quantity of Congress was virulently opposed to this. So even if tomorrow the National Security Council and the President all say, yes, let's move them up here and do Article 3 prosecutions, you'd still have a lot of congressional opposition. What sort of arguments do you have non-politically as the former prosecutor from a legal perspective or even a military perspective to say it's perfectly all right to move them up into the into the United States, out of Guantanamo Bay, and into a detention facility that's more in line with what the world expects?
Right. I think General Martin has said there's about 20 that we intend to either have been prosecuted or we intend to prosecute. So it's a pretty small group. Remember, we were told they were all the worst of the worst. So out of 779, there are about 20 that we want to prosecute and hold accountable. I think with the military commission, like I said, in 7 years, we've had 7 trials in 12 years. 5 of those, the D.C. Circuit, the civilian court, has said the offense they were convicted of is not a legitimate law of war offense. So they haven't been a huge success. In the meantime, we've prosecuted hundreds and hundreds of similar cases in federal court successfully, securely, and gotten what I think most people would consider good results. The president, I get on Twitter quite a bit, when I comment on this, people, well, Congress has made it impossible, it's not the president's fault, or the most common response I get on Twitter is, you suck, which is, which is not a particularly helpful comment, but Congress has made it difficult. But when President Obama took office, remember John McCain and Barack Obama both said, well, I want to close Guantanamo. So I'm curious, I wonder what would happen if McCain had won. Would Guantanamo still be open? But it became the other side. Anything Obama was for, they were against. So he had this backlash. And I don't think he was prepared for the backlash. I think he thought, look, we both agree we ought to close Guantanamo. So I think when he signed that order on January 22nd, 2009, it was kind of like over and done, and he wasn't prepared for the backlash. And healthcare reform was number one, and the economy was crashing. I just don't think he had the backbone to get it done. But for the first 2 years, he had a majority of Democrats in both the House and the Senate, until you had the Tea Party kind of swept in. And that's when the legislation began. The 2011 National Defense Authorization Act that President Obama promised he would veto if it included the NDAA, included those provisions. Well, 2 years in a row he did that. On New Year's Eve, it's become, which is going to drop first, Obama's veto threat or the big ball at Times Square? And the veto threat has dropped twice, and he signed the NDAA that limits his authority to transfer detainees to the U.S. But my view is, look, if you got the unilateral authority to send a civilian agency to kill an American in another country, I think you've got the unilateral authority to bring detainees to the U.S. for prosecution in federal court. Now, there will be complaining, for sure, but, you got to man up and get in there and keep your word. You promised you were going to do it, and do it. Because this has just been a blight on our reputation with our friends and our enemies alike. And so we've tried and failed, and we need to give up on this effort and use the courts that have the respect of the world.
Colonel, God bless you for taking the brave stand you take.
Thank you.
Can I ask you to look into your crystal ball? 20, 30 years from now, the way things are going, will the Fourth Amendment be as dead as the 10th Amendment by then?
Well, it certainly seems that, again, if you're my age and you look back at the TSA pat downs at the airport, or the whole NSA spying program, the surveillance program, which they denied doing, and now it's pretty clear. And again, it's an interesting debate with Edward Snowden. Is he a hero or a villain or somewhere in between? But we've certainly gotten more comfortable. And like I said, I think it's become the new normal. We've got a generation that grew up in the post 9/11 environment where that's just the way it is. And so I'm hoping people will pay attention. I mean, if you really believe in the Constitution and liberty and what it meant to be an American, you ought to be offended at what our country has done for the last 12 years. So I'm hoping, I remember when I was your age, 30 years ago when I was in law school, and I remember thinking my generation, because I grew up in the post-Watergate Vietnam era, and I saw how my father's generation had screwed up the country, and my generation was going to go out and change the world. Well, we haven't done such a good job. So I'm hoping your generation will do what my generation has failed to do, and to make us that shining city on a hill that we ought to be, and we can be if we just had the guts to do it.
One last question.
All right.
So when General Martins was here last month, he understandably sort of gave quite a defense of the commissions that he's now presiding over as chief prosecutor, and he acknowledged many of the problems and inadequacies that were part of the commissions passed by Congress. But he would maintain now that pretty much they're fixed, and makes the argument that really the commissions are needed, however, for two primary reasons. One, in some instances, some level of hearsay must come in, which is accepted in other tribunals outside of the United States. And secondly, for some reasons of security and classification, that they couldn't be prosecuted in the federal courts. I just wonder what you say to both his praise of the current commissions and the need for them still.
Well, a couple things. One is, I think the current iteration of military commissions are vastly improved over the original. I mean, the original concept was you had some civilian political appointees that looked back at the trial of the Nazi saboteurs in 1942, which if you're familiar with the case, you had the 8 Nazi saboteurs that were dropped off by submarine, came into the U.S. One guy decided he was going to go to the FBI and be a hero and turn everybody in. So between June of 42 and August of 42, you went from capture to prosecution in a military commission to Supreme Court review to execution and burial by the Anacostia River in Washington in 100 days. So it was swift, it was severe, and it was secret. And people saw that and said, hey, this worked really well in 1942, let's do it again. And so here we are, in 2013, and we've completed 7 cases, 5 of which, the appellate court has said were convicted of offenses that aren't really law of war offenses, so it's been a colossal failure. And in 2007, when I stood right here, under the original Bush order, I said, this is good stuff, this will work. And then the Supreme Court said, no, it's not. And then we passed the Military Commissions Act in 2009, and I went out and said, hey, this is even better. It was good before, but this is even better now. And then President Obama shut that down. And then they have the Military Commissions Act of 2009, and we're saying, okay, this time, it's really justice. And I think the world is, I think we had the opportunity to do this and do it right. And I think, to me, it's no longer a question of could we do it, it's should we do it. Because you could give KSM the most perfect trial in the history of jurisprudence, and 90% of the world is not going to believe it, because we have screwed this up for so long and told the world over and over and over, this time we got it right, this time we got it right, this time we got it right. And if you look at the failures they've had at Guantanamo, where the sound went out, the judge thought he was in control of the courtroom and the sound goes out, and it turns out there's a secret CIA monitor somewhere that controlled the courtroom, and you've spent 2 days arguing over whether Khalid Sheikh Mohammed can wear a camouflage vest to court, and all the things that aren't issues in federal court because we're making it up as we go at Guantanamo. So I think they're vastly improved over where they were. But again, because I didn't hear his talk here, but I've heard General Martin and Attorney General Holder at other forums where they've said, well, it's nearly, it's virtually as good as federal court. Well, if it's that close, then why do we need 2 different processes? And we proved with Galani. I mean, Galani was one of the high-value detainees held at Guantanamo, held by the CIA, prosecuted and convicted in federal court and doing life without parole. So we have proven that the federal courts can work. We just prosecuted Bradley Manning. I was an expert witness for Bradley Manning at his court-martial recently, which was a case that was centered entirely on classified information. I mean, every charge against him was based on classified information, and we had a court-martial, an existing process that was largely, I mean, there's some critics of the proceedings, but they were largely open in a credible, forum, with existing rules and procedures, and he was convicted, and the world's still turning. So we've got federal courts, we've got court-martials. I think what Guantanamo and the military commissions say is not so much about what they did to us, it's about what we did to them that we want to hide from the public. I mean, with KSM, I can tell you, like I said, we were building the case against these guys without using any information we obtained with enhanced interrogation techniques. So like with KSM in the 9/11 cases, we were building the case having set aside and walled off anything they said in U.S. custody. And I can tell you, any attorney that can't convict KSM without using his statements ought to find another line of work. So